IGP training to Dheeraj Kumar, IGP Law and Order to Lalreka Chante, IG Prisons, fellow officers, respected members of the community, members of the and friends of the media, civil society, and all those who are present here. As just has been stated by IGP Law and Order, that the new criminal laws have come into force from today, and like the other states and union territories of the country, Mizoram police has also been fully geared up to implement these new laws. These new laws have a game-changing aspect of how the criminal justice system used to operate and how it will operate in time to come. First and foremost, it is a law which is framed by our own parliament. It is not a British legacy anymore. As you might be aware, that the Indian Police Act of 1861 came about after the first war of independence, or as the British used to call them, the mutiny of 1857. And those laws were created to ensure that the British Raj continued, and these laws were actually implemented in Ireland first and then brought to here in India. So Ireland and India were the laboratory of the British, and we continue to have that laws for almost 150 years. Now these new laws have been framed. The essence of these new law is that instead of punishment, it would be justice at the center of law. Instead of the fact that the complainant has nothing to say about his complaint, it would be victim-centric. Those who are facing the wrath of the acts done by criminals and individuals against them, for example, women in particular, children, they would be in center of these criminal laws. So there would be an aspect of quick and easy registration of crime. Now you don't have to go to X police station and they cannot refuse to say that this does not belong to my jurisdiction. Go to some other police station. You can register the case there itself. You don't have to know which police station I am living in. If there is a case which is to be registered, it can be registered in any police station. And then it is the job of the police to transfer the case to the relevant police station and take up the investigation. Similarly, electronic FIR would be launched. In times to come, Mizoram police will also start this process, the EFIR. We have some technical aspects to deal with, but once it is sorted out, we would be able to march it up the way other states would be doing. There are some changes which are fundamental which is happening. One of them is that there would be now speedy trial of the cases. I hope that the judicial process would be in place so that the cases which are brought for the consideration of the courts will have a time-bound schedule to dispose of the cases. The cases will not linger on for years and years and years. Other than that, timelines have been prescribed for various sections of law. Similarly, focus has been given on child rights, women rights, as I mentioned, No women can be cheated or deceived, or physical relation can be formed on the pretext of marriage. If that happens, it would automatically translate into a crime. There were various judgments over time issued by the Supreme Court, which has become a procedural law for police. For example, use of handcuffs. In 1995, in a D.K. Basu versus State of West Bengal, the Honorable Supreme Court has debarred the police from using handcuffs, except in those cases which are very, very grave in nature. This has also resulted in problems for police. While on one hand we have criminals which would be terrorists, who could be rapists, who could be serial killer, who could be into the acts of drugs and other kind of trafficking in serious offences, but you cannot use to handcuff them. That would require that everywhere you go, you have to carry that person along with, so 2 constables for one individual. And they are holding hands, and there are so many cases where the criminals have used this opportunity to escape from custody. So now in those cases which are serious in nature, by reducing down in writing, earlier we have to take the permission from the court, but now the police can, in serious offences which have been prescribed in these laws, can use handcuffs. This is not to humiliate a good citizen by putting handcuff against his minor offence, but only for serious offences which I mentioned of serial killers, rapists, and those involved in serious cases of drug trafficking and terror cases. Other than that, these laws prescribe timelines for the police to finalize the case, timelines for the judicial officer to finalize the trial of the cases. So there would be a time-bound justice, which I mentioned in my opening remark, that instead of punishment, justice for everybody would be sought after. But the most important aspect of these 3 new criminal laws would be use of technology. The use of technology in recording the search and seizures, the statement of witnesses, even the statement of accused. Also, for all those cases which require punishment, which has punishment for more than 7 years, would have to be mandatory over a period of time. Forensic specialists have to go and collect the evidence. So that means there would be a paradigm shift. The discretion of the IO would be reduced. The search and seizure and the audio-video recording will help the court to understand what happened, how it happened. So the omissions on the part of the police investigation can, in some ways, be mitigated. There are so many changes which I don't want to talk about, but I just want to emphasize that the new criminal laws, which include the penal code, the Bharatiya Nyaya Sanhita, new sections have been added, certain superfluous sections have been deleted, new kind of punishment like community service has been prescribed. So that means there would be less number of individuals in jails. IG prison would know there is so much of pressure for 100 people capacity jail. We already have more than 400 people in jail. So there would be less pressure on jail infrastructure, and the person will have chance of redemption of his or her guilt. Mizoram as a society is very blessed, because once I'm not saying it is a crime-free society. There is crime. And when I came to Mizoram, I had a different opinion. But there are crimes which are very serious in nature. And this is fundamental because of certain structural problem in the society of Mizoram. For example, I give you from an outsider view. I'm an outsider to a Mizoram society. There are a lot of houses, homes which are broken homes. When I say broken homes, people, the husband, wife remarry. There are divorces and remarriages. Because of that, there are elements of stepchildren and stepfather and stepmother. And we have found in so many cases, POXO, violation of children by the stepfather, is a recurrent theme, which doesn't happen very frequently in other parts. But here, because the father doesn't consider the stepdaughter as a daughter, these instances come into play. So now there would be a possibility for the police to investigate these cases in a much more vigorous manner, though we still have a very good law in POXO. At the same time, Mizoram has a unique quality, and that attribute is that people confess to their crime. It may be due to how the society is structured. It also may be due to the influence of Christian values in the society, where confession is part of the religion. So once they are caught, people do confess in the court that yes, this has been done by me. So it is easy for the judge to pronounce the judgment. That is why there is a conviction rate which is more than 90%. The police has a role to play, but let me tell you, police will not take all the credit. It also goes to the society per se, that how the society is structured. But that is not the case in various other parts of the country, where people contest to the highest level before confessing or before they are given sentence. Confession is out of place. People don't confess, generally. So I have given you the good and the not so good part of Mizoram society. But there are so many other attributes which are covered by these three criminal laws. The procedural laws have also been changed. The element of involvement of technology in day-to-day policing, in implementation of these laws, the powers of the police have not been increased. Generally, there are misapprehensions that the police has been given enormous power under these new acts. Maybe in some cases the powers have been reduced, regulated or moderated. And in some cases the powers have been subjected to technology. So overall there would be a change. I am very happy, and I must thank my training branch, especially IG training and his staff, as well as officers down the line, who have trained almost all of our officers at the cutting edge level who are involved in policing, in investigation about these three new criminal laws. This process is a continuous process. Training, retraining, because these are new laws, so many changes have come. There would be some hiccups. There would be certain issues which will emerge which we cannot anticipate today. Also, there would be certain legal issues and legal problems which might emerge. That is why under the leadership of our Chief Secretary, there is a steering committee where all the stakeholders, which include police, prisons, which include the law department, which include the forensics, which include the lawyers and the judiciary, all have been made part of this change. And this change is not only for police and laws, this is a holistic change. There would be hiccups, there would be certain issues which will emerge, but overall I am satisfied and I am happy to state that we are geared up for implementation of these laws, and I hope this will bring some change of image for police. This will bring the government and the criminal justice system easily available to the people who are facing violation of their rights, and will also facilitate the downtrodden and the weaker section of society. I am happy to be part of this function, and I am thankful to all of you for hearing me speak, and I will now request SP Aizawl to make a brief presentation. Thank you very much.
Thank you, sir. Now I would like to request Rahul Alwal, IPS, SP Aizawl, to give a slide presentation on overview of the 3 new criminal laws.
Respected DG sir, respected IG sirs, DIG sirs, and all the senior officers, and the members from the NGOs and the local leaders, and all the police fraternity. I welcome you all today, and I want to give you a small presentation on the 3 new acts which have started implementation from midnight today. So, from 1st of July, before we used to have 3 laws, which are Indian Penal Code, Criminal Procedures Code, and Indian Evidence Act. So these 3 old acts have been now shifted to 3 new laws, which are Bharatiya Nyaya Sanhita, which replaces the IPC, Indian Penal Code, Bharatiya Nagarik Suraksha Sanhita, that is the Criminal Procedure Code, it will be replacing this Criminal Procedure Code, and Bharatiya Sakshya Adhiniyam, that will be replacing the Indian Evidence Act. These have a lot of special features in this. One is many new offences have added, as our DG sir and our IG sir were mentioning. The new offences which have been added in these cases, so we will be discussing them. The main part of this 3 new acts are embracing the technology. For example, the videography and electronic communication. These have been a very key aspects of this 3 new laws. Forensic examination has been made mandatory in few cases. For example, more than 7 years of imprisonment, and also involvement of forensics of one of the important stakeholders and taking them along in different seizure of evidences and also visit of scene of crime. So these all things have been incorporated and made stringent in this 3 new laws. When the FIR registers, the victim was no more visible. It was more that the system, the state takes upon itself the responsibility of getting justice for the victim. Now it has been, and also the IPC and other procedures have been more of criminal specific, like to give him punishment and more of focusing on the accused. But these 3 new laws have been more of victim centric, where the victim has been given his or her due representation in each stage of the investigation and also in the trial. Many time-bound clauses have been added. For example, investigation, time-bound investigation, time-bound registration of statements by the magistrate, time-bound completion of trial, time-bound report to be given by the forensics and also by the medical examiners. So there are many time-bound clauses are included, which will ensure that the victim gets justice as soon as possible. The accountability on police have increased manyfold in this. it starts with the registration of FIR. It is mandatory for the police officer to register the FIR, and if not, an FIR can be registered on the police officer himself. And also many different provisions of law have been are included, and even there, when there is disobedience to any lawful orders and lawful instructions, the police officer do, there are penal provisions even for the police officer. So there's a lot of accountability on the side of police. Changing times, as this has been a very archaic law, with the changing times, we need to have a law which is forward-looking. It has been one of the reformative acts which have been implemented in India. And as Lisa mentioned, the community policing aspect has added into the IPC punishments, erstwhile IPC punishment, Bharati Nyaya Samhita punishment. So where for minor punishments, community service is one of the punishments. So by that, the burden on the police, on jails will be less. Let's first dive into the BNS Bharati Nyaya Samhita. Most of the IPC provisions are still there, but there is a recognition of the new offences, and also some offences which have been struck down by Supreme Court, Honorable Supreme Court, have been removed. There are 20 chapters which contains the 38 sections. It has been made more structured. Before, in the erstwhile IPC, it was the abetment and the and even the conspiracy and other different part of the sections were in different parts of the IPC. But now it has been made very structured. Crime against women, bodily offences, and even the abetment and also other kind of allied sections are also joined together, and it has been made more structured. Separate chapters have been made, as I mentioned, so that will also enhance that. Separate chapter has been made for crime against women and children, and about 175 provisions have been modified, and 20 new sections have been added, and 19 sections have been repealed. I will just discuss few of the new offences which have been added. First is organized crime. Before, there was no specific section for organized crime. Now, organized crime is anyone who is doing in concert or in as a coordination 2 or more people for the financial and material gains. It is considered as organized crime, and there is enhanced punishment for those kind of crimes. Similarly is the petty organized crime, where it is used more for theft, burglary, and petty crimes. So in this also, a specialized section has been made. For terrorist acts, we already have UAPA Act. On top of it, even in the BNS, we have separate sections for the terrorist-related acts. They have made some special provisions of SP and above to decide whether to register under the BNS and or UAPA, and also strict punishments have been also been added in the to counter the terrorism acts. Lately, India has been victim to many of the mob lynches which is happening all over the India. So to bring these mob lynches down and also have effective punishments for them, a separate section is added for the mob lynchings. So in this also, if it leads to any kind of death, so punishment of death can also be given to them, and also when also any grievous hurt to any person, in that 7 years of imprisonment is also prescribed. Next is snatching. Snatching per se term was not there in the erstwhile IPC. Now, specifically it was defined in the new BNS Act, and it was because many chain snatchings and purse snatchings do happen, and for that enhanced punishment should be given. Accordingly, they have added this section so that this side of the part is also included. And crime against women, many provisions are added. For example, before it was only by a lot of Supreme Court judges judgment were there, which included that any false promise to marriage, any false promise to employment, if somebody takes sexual favor, it is also considered as rape. There is not a consent given by the lady. So in those provisions have been very clearly mentioned, and also hiring and engaging the child to commit offences, and also it has been made gender neutral. Before it was in some instances like voyeurism and even disturbing of women. I mean, it was more of male doing an offense on the female. But it is now any gender can do such kind of on a female or a lady. So those any offences where voyeurism, stalking, or any other things, all this have become gender neutral. And the gender has also included the third gender, which is transgender. The acts of endangering the sovereignty, integrity, and unity of India. So separate sections have been added, and more enhanced punishment also is included in this. Before, these are the main sections which have been used by the erstwhile British era to keep a tab on the freedom movement and also ensuring that suppress any kind of such activity. So these acts are also redefined in such a way that it is more on the interest of India than on the erstwhile interest of continuing the colonial era. There is enhanced increase in the punishments and also the fine amounts. There is increased penalties for the grievous cases, heinous crimes like rape, gang rape, death by negligence, etc. Minimum mandatory punishment. This is one important contention for us also. Whenever we do any kind of investigation, ensure the conviction of the person. If it is there up to 3 years, up to 4 years, up to 7 years, the judiciary has enough flexibility to give as much as possible, even from 1 month to 0 to 7 years. So for example, it is up to 7 years. So this particular provision has helped us that minimum punishment has to be given in some of the important heinous crimes. And also community service, I discussed earlier, that also has been added as punishments. Next. So I will just tell you what is a community service. Community service is doing any job which is helpful for the public, but no particular remuneration will be given. So it is an actually standing practice in other developed nations. So that new concept has been added in our BNS, so that in small petty cases, like go back, like suppose a theft has happened of less than 5,000 value and he has already repaid. For example, a lot of people here, even here, a lot of burglary and theft happen where it is grocery items or a small amount of money or cash which is less than 5,000. If the accused repays that amount, then he will be given community service. For a small example, next. Now we'll go to BNSS, Bharatiya Nagarik Suraksha Sanhita. Now the important aspect is the zero FIR. As our DG sir was mentioning, no OC, officer in charge of a police station, can deny registration of FIR solely on the basis of jurisdiction. He or she cannot deny saying that it doesn't come under my jurisdiction, so I will not register, you go to other police station. So it has been now mandatory and strict now. Before there are provisions of zero FIR, but it has been now compulsory for the officer to ensure that otherwise action can be taken on the concerned OC also. So zero FIR is done, and in that zero FIR, basic procedures are done, and then we'll transfer the case to concerned jurisdiction. EFIR, anyone can electronically send the complaint. Now you can even send on email and other things also. But the provision is that you have to come mandatorily within 3 days and sign the complaint. And also, in case of any serious crime, if you report, even so modo FIR can be registered by the police officer themselves and take over the investigation. Preliminary inquiry, it's already been there before as per the Supreme Court judgments. So whenever there is no cognizable offence made out, whenever you complete the complaint, which we are not entitled to investigate, it doesn't appear that we can investigate. And even when we can investigate, but you have not clearly mentioned the cognizable part of it. The things are not very clear in that. So we can do a preliminary inquiry of not more than 14 days, and if it takes more than 14 days, we have to mandatorily register FIR. So these things are also have been made mandatory on the part of the OC to only in few cases. You cannot do in any case, and also whenever it is very clear the case has been made out, some offence is been alleged, even if it's alleged, need not be true, need not be verified to be true at that stage. But if it is alleged, then we can register the FIR. Free FIR copy, before it is only given to the complainant, now even for the victim it is given. forensic examination is mandatory. Nowadays, the defense have become more and more updated, and they are trying to get acquittal by focusing on the procedural part of it. And also, when a criminal aspect comes, it is beyond reasonable doubt. So it is like, if the defense, then accused people, if the accused gives an impression to the court that something else could have happened and there is a probability in that, then they will acquit the case. By ensuring forensic investigation and videography of the scene of crime and seizure of the evidences and statement of witnesses, this will ensure that they cannot deny, no one can deny, even in the trial stage. The witnesses can't turn hostile. Witnesses turning hostile is one of the important, major reason for our acquittal cases, even in Mizoram. And also, when we have a forensic forensic seizures and recording of such seizures, will ensure that the court will make an impression that this is the only possible implication that the person has committed the crime. So, making it mandatory will help us in ensuring the conviction. Witnesses, so in witnesses also, there is the burden on the witnesses that we have been calling them and asking them to come. So these provision also have been reduced, mandatory requirements have been reduced. Now they can be done videography, and also they need not come to police station if they are a minor, less than 15 years, and also infirm or physically, mentally disabled. So they don't need to come physically. At their place, we can go and take the statements and record the statements. Videography has to be done. And also they can they need not come to the court if the magistrate says that videography can be done. Video conferencing can be done. Recording of statements I was mentioning, mandatory on the part of the magistrate. Prior permission is required. Now again, in the cases where there is a less than 3 years of imprisonment is there, very petty crime, 3 years of imprisonment, but the person is elderly and infirm or physically, mentally disabled, so usually there is no requirement of arrest. But to keep a tab on the investigating officer that they are doing it properly, so if they want to arrest such a person, less than 3 years imprisonment, but also is infirm, mentally and physically retarded, so that place, DYSP's permission is compulsory. Now we'll go to the last Bharatiya Sakshya Adhiniyam. It is replacing the Indian Evidence Act. There is no much difference in that, but important and the main important thing is the inclusion of technological interventions, like for example, inclusion of the video conferencing, admitting the videography, and also electronically transmitting different kind of summons and even the different notices and these kind of things. So all these electronically collected evidences have become admissible in court of law. So that provisions have been added, and also various provisions which will make the trial fair have been added. So embracing technology, I was mentioning that witnesses and accused and experts, anyone can be, now video conferencing can be done, they need not come physically. And also there are a lot of definitions have been changed where the digital records have been added, where they can be admissible in the court of law. Thank you.
Thank you, sir, for your informative presentation. Now I would like to call upon Pularring Paswal, Additional SP Admin, to present the vote of thanks.
First of all, I would like to thank our DGP sir for gracing the inaugural function for implementation of the new 3 criminal laws, BNSS and BSei. With his active support and guidance, Mizoram police are well prepared for successful implementation of the new criminal laws. Secondly, I would like to thank our IGPs, IGP LNO, IGP training, DIGs, and other senior officers from BHQ and other units for their valuable support and guidance, apart from sharing their resources and manpower in making this function a successful event. Besides, I would also like to thank our invitees and officials from other departments in taking time in attending these inaugural functions. Suan foina ato berle apoy mo bera suan kan miso mate do puile zar kot kotang shoi Tute local council YMA MUP MHCP MJA te kan som te ngai pon moa in hun tak senga voina local zong te in zawai chunga lom thu kan soya chuan he swal dawna konga le I dan thar kan hmanna hian min tro yoma I heito min tro pui zel turin song hal bok chung he kamanga.
Thank you, sir. With this, the inaugural function has come to an end. I would like to request everyone to remain seated and refreshments will be served shortly.